Hi, everyone. I would like to, I have already been introduced, so I'll just go straight into the presentation, which is on refugee recognition in Kenya and South Africa through the lens of the Global Compact on Refugees. So this project or this presentation is coming out of our research that we did as part of the RefMIG project, which looks at examining refugee recognition practices in 4 countries initially: Kenya, Lebanon, South Africa, and Turkey. I was doing the Kenya and South Africa bit, so that is where I come in with my presentation. But also RefMIG is rolling out a survey on UNHCR RSD processes and practices, and another one for legal aid organizations that represent applicants in UNHCR mandate RSD. So anyone who is interested and fits that profile is very welcome to participate in it. More information is available at the RefMIG website indicated there. So going into the discussion, refugee recognition processes. In Kenya and South Africa, both countries are party to the UN Refugee Convention and its 1967 protocol, as well as the 1969 OAU Refugee Convention. And they have both consequently enacted refugee acts that seek in ways to domesticate the provisions of these instruments. So going to the factual elements, Kenya has a refugee population of about over 500,000 refugees, of which over 450,000 are recognized refugees. It also recognizes refugees on a prima facie basis. This is about 85% or 86% of the population. Previously, it was for Somalis as well, but currently it's only South Sudanese who benefit from this recognition. So that means that it's just under 15% that do undergo refugee status determination. Also, Kenya has an encampment policy. So 84% of refugees and asylum seekers reside in refugee camps, while it's just about 16% that are urban dwellers. Also important to note is that UNHCR has played a predominant role in Kenya refugee status determination from around 1991 until July 2014, when the Kenyan government resumed refugee status determination. So on the other hand, South Africa, by the end of 2020, it hosted about 76,000 refugees and a higher number of asylum seekers, coming up to about 170,000. So South Africa only recognizes refugees through an RSD process, individual status determination, that is since the law came into force, although within the law there is a provision that the minister may recognize categories of persons as refugees on a prima facie basis, but this has never been triggered since the law came into force. So the RSD in South Africa is government managed and a funded process. It's wholly in the hands of government, and UNHCR only comes in to assist as and when invited by the government. Also important to note is that South Africa has an urban and self-settled refugee policy and does not have an encampment policy as in Kenya. So looking at the Global Compact on Refugees, there are aspects of the Global Compact on Refugees. If you look at the right of the screen, I have included those aspects of the Global Compact that I do comment upon on the left side. So one is registration, which is meant to enhance, which is meant to kind of like sieve out people that may need special needs or special attention. That is part of the rationale for the registration. So Kenya, since it resumed RSD, the Kenyan government is using UNHCR's global registration system. That's progress, although with restricted access, which is a bone of contention between the government of Kenya and UNHCR. So all refugees that come to Kenya go through the initial registration phase. For prima facie refugees, that's all they have to do, register, and then they can proceed to apply for their documents, refugee IDs. So registration does screen out for security reasons, protection needs, as well as exclusion flags, among others. But it's also a way of assessing the special needs of people that may not be able to reside in the camps. For example, registration is going in the city, is happening in the city, urban areas as well. But once you register, you are advised to go and complete the process in the camps, unless you have medical reasons, educational reasons, or protection needs and other identified special needs that may make you exempt from going to the camp processes. So we can say there is a rudimentary process that enables assessing special needs, although that is yet to be assessed how it's fully working. South Africa, on the other hand, also has its registration process, but the challenge is accessing that process, the offices or the officers. Their physical distance, South Africa is quite a large country, and there is such a physical distance to the refugee reception centers. And this has been aggravated by closure of some refugee centers, reception centers. So it has made it worse on those that have to move to and fro. There are the long queues that are legendary in South Africa, gaining access into the office, the jostling and bribery that happen outside the office. And also under the current law, there is the legal window within which to apply for asylum is only 5 days. And South Africa also runs a system of nationality days. So it only tends to specific nationalities on specific days. So it is easy to kind of like miss that 5-day window. And currently, as it is, before you get into the office, I would say the system is not as conducive to assess the special needs of clients. By the time they do get assessed, maybe it's a bit too late. So the Global Compact also does have provisions on access, on fairness and efficiency, and we are going to see how these work out in practice in Kenya and South Africa. So with Kenya's prima facie recognition, it manages to recognize a very high number of refugees, and it has a very low rejection rate, which is less than 10%. But also, having taken on the RSD from UNHCR, it has adopted case processing modalities, simplified case processing modalities for specified groups of people that do not undergo the full rigors of the RSD process. So it's more simplified. South Africa, on the other hand, retains its full RSD for all who apply, and it also has very high rejection rates of over 90%. So the common challenges in both countries are the long waiting periods, whereby you have an average period if you manage to have your case determined within 2 years, you are lucky, but most cases are 2 years and beyond. And this has its own stress and strain on the refugees and asylum seekers. There is also the poor or lack of communication and information on the various processes involved, especially in the status of one's claim. And the only way that applicants may get apprised of the status of their case is through the appointment letters that are ubiquitous in both countries. The other issue also regarding efficiency is the high backlogs. Kenya's, even though it has implemented the simplified processes, it still has a backlog of over 50,000 cases, while South Africa's was over 220,000. So South Africa has pledged under the Global Refugee Forum to eliminate its backlog, especially at the appeal stage, which is about 150,000, and it has embarked on that project. So we are yet to see how that works out. But also another sticking point in South Africa's RSD is the corruption and bribery that is quite prevalent. So fairness in the process, the Global Compact does not define fairness, which is quite a fluid term, depending on who is interpreting it. So it usually tends to be interpreted in terms of procedural and administrative justice. So I'll kind of like just zone in on the one aspect of appeals. So UNHCR lacks an independent appeal mechanism. So while Kenyan RSD was being handled by UNHCR, there was no opportunity for an independent review, which has now become available since 2016. So South Africa, on the other hand, has always had this independent judicial review, which casts a spotlight on an otherwise inscrutable RSD process and practice. So there are scores of judicial decisions in that respect. So in both countries, the appeal processes are neither well explained nor understood by many of the applicants, which highlights the need for legal aid services and legal representation, which is also scanty in these services. So the appeal process is kind of like out of reach for many of the people that would like to utilize it. So going to the main kind of like a highlight of the Global Compact is to operationalize the principles of burden and responsibility sharing. And one of the ways it has done that is through the Global Refugee Forum. well, its pledges and contributions from various stakeholders. So Kenya has pledged to strengthen its institutions and community structures, and it is doing that with UNHCR, which, by the way, still funds the substantial part of the RSD operations. The government is not really funding most of it. And then it's also strengthening its refugee regime through the bill that is now in Parliament, hoping that it will be passed soon. It has been there for quite a number of years. But also worryingly is that Kenya is also threatening to close the refugee camps by June 2022. And there is actually a roadmap that has been drafted by the government and UNHCR to that end. So it leaves the future of refugee protection in kind of like uncertainty. South Africa also has embarked on its backlog elimination strategy, but on the other hand, it has come up with amendments to its refugee acts that kind of like tend to restrict the asylum space as it were. We can talk about that later in the discussion. So to conclude, the refugee recognition processes, particularly RSD in both countries, seem to be buckling under pressure from various sources, and there is still plenty of room for improvement, even on what currently exists. Despite the Global Compact on Refugees and its promises, there are mixed messages from the host countries. The future of refugee protection remains uncertain and unpredictable. There are worrying trends in both countries, which seem to depict that the Global Compact on Refugees is a sublime promise rather than a realizable and practical assurance for the global refugee regime. So thank you for listening. I await more questions in the discussion.